The first matter to come before us this morning is State of Ohio versus Matthew Gorbe. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know ahead of time, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We have read the briefs and we're ready to see when you are.
Thank you. And if I could, I'd like to reserve 5 minutes, please, Your Honor.
Certainly.
Thank you. May I proceed? Thank you. Normally, I would say at a time like this, first of all, my name is Russ Bazzelli. I represent the appellant in this case, Mr. Matthew Gorbe. Would the court wish to hear a recital of the facts? And I can recall Justice Whitmore saying to me more than once, Mr. Bazzelli, for the last time, this is your argument. You do it how you want to. So,
How did you know that was about what I was going to say?
I keep that in mind. I keep that in mind. I always have to honor what Professor Kirkwood taught me long, long ago in law school. On November 27, 2014, the facts at trial revealed that Crystalline Gorbe, in an emotional tirade after finding on her husband's cell phone information about a dating site and how to delete internet browsing history, that Matthew deserved to be punched in the face, and she admitted that at trial. She then took Matthew's phone after Matthew left to go get a tow truck, a snow removal truck, because that's what he does as part of his job when it's snowing heavy, and she finds in that cell phone a text from another woman. In my world, because I do a little bit of domestic relations work, it's flame on. And what do I mean by that? Mrs. Gorbe testified at trial that after finding this text message, that she proceeded to attack her husband. She punched him, she kicked him, she bit him, and as Matthew was retreating, she took a lamp and she pummeled him on his neck and back with such force that she broke the lamp and shards of glass remained on the floor. It doesn't stop there though, because after this happens and confronted with what she has done, she then calls the police, 911. And she fabricates a story not of one attack, but 2 attacks that she suffered at the hands of her husband. This creation theory, as I call it, continued through trial, where Mrs. Gorbe then enhances the facts of this case to say that she was repeatedly strangled. Strangled to the extent that she lost consciousness. Now, this isn't in any of the earlier paperwork. It's not in the 911 phone call. But it seemed with time, her memory improved. Unfortunately, she continues then to provide different stories of the attack, including these passing out incidences, on the heels of filing a divorce case, which came into evidence, and a custody case involving the Gorbe's yet unborn child. The testimony at trial was in and of itself inherently contradictory. The police officers, 2 officers who were lauded as being experienced veterans, who denied the existence of any glass shards on the floor from the broken lamp, even though Mrs. Gorbe said they did exist. There was a trial, and at trial, the evidence that has already been cited in my factual summary was put on the record. There are 3 assignments that I have raised in this case, and I will focus on the first assignment. The second and third, insufficiency of the evidence and manifest weight, are dovetailed into and bootstrapped into the first argument, and that is Matt Gorbe was denied a fair trial. He was denied due process. It's my limited understanding in the case of State v. Smith that our Supreme Court has said that a prosecutor has to avoid insinuations and assertions which are calculated to mislead the jury, that a prosecutor may not make improper remarks that prejudicially affect the defendant's substantial rights, and he must avoid expressing an opinion. he can express an opinion as to the defendant's guilt, the appellant in this case, Matthew Gorbe. When you look at the record, I asked the court to consider the transcript cites at pages 341, 344, and 345. In those citations and the matters contained within the brief, the prosecutor spends a lot of time telling you about how his witnesses are worthy of belief. And I understand, being a former prosecutor, that prosecutors get to strike hard blows, but they're not supposed to strike foul ones. And the foul ones in this case are referring to Matt Gorbe's testimony and his story, that it's not worthy of belief. The prosecutor refers to Matt's testimony as a story at page 343. He says that it's trying to fit a square peg into a round hole at page 347 through 348. He tells the jury, that's not very believable, talking about Mr. Gorbe's testimony. It's tough to keep your story straight. And I suggest, ladies and gentlemen, he says, that doesn't make sense. It's not reasonable testimony. I understand, in reading those passages and going through the transcript, you don't come right out and say he's a liar. But it's still inherent, it's intrinsic, it's insidious, and it violates the Supreme Court mandate. I would ask the court to consider that the prosecutor's remarks in closing were improper, and following the regimen in State v. Labriola from this very Court of Appeals, that these arguments being made deprived Matt of a fair trial. As to the facts that I argued earlier, I just briefly remark that as it relates to the insufficiency of the evidence and the manifest weight, this was a highly emotional trial. Understandably, Mrs. Gorbe is pregnant. Having said that, she also proceeds to repeatedly assault her husband. There is no excuse for that. There is no defense for that. This is not self-defense, it's an admitted attack. The jury lost its way, caught up in the emotion. I asked the court to review these citations that are contained within my brief, to review the arguments as they have been outlined here today. I thank the court for its patience, its counsel. Thank you.
Morning. May it please the court, my name is Vince Vellucci. I'm an assistant Medina County prosecutor for the appellee of the state of Ohio. I will start, and I believe primarily focus on the defendant, Mr. Gorbe's first assignment of error, the prosecutorial misconduct issue. It's claimed that the prosecutor obviously committed prosecutorial misconduct during his closing argument, and you heard some statements that were cited there. The general test here is first that, with respect to closing arguments, is that first we have to ask ourselves, were the remarks improper? And second, did they prejudice the defendant to the point where they actually changed the outcome of the trial? However, in this case, it's actually even a little bit more different. It's because it's plain error, because the closing argument was never objected to by the trial court. So now you not only have to show that there was error committed in the closing arguments, which we don't believe Mr. Gorbe can show, you have to show there was obvious error, and of course that the outcome of the trial was changed by these couple of statements. He can prove neither in this case. Not only was there not plain or obvious error committed, there was no error committed in this case. In fact, Gorbe's brief doesn't actually, other than citing the plain error standard, doesn't explain why each of these individual statements are plain error as opposed to just normal error. I would say that he fails to single out specific statements and explain why those are improper or prejudicial. He just makes he lumps them all together and makes general assertions like the fact that the prosecutor's argument crossed the line into impropriety. That's argument that's made. It's just a general assertion. But it's not improper for a prosecutor to point to evidence and argue why some should be believed and some should not be believed. That's the whole point of a closing argument. We know that the prosecutor cannot mislead the fact finder. We know that. We know that a prosecutor cannot express his or her personal belief about the credibility of a witness or about the defendant's guilt. That's well established and there's no dispute as to that. But we don't have any of those things in this case. It's not even close. We don't have anything like that in this case. In fact, it's not even prosecutorial misconduct to characterize a witness as untruthful or even as a liar if the evidence reasonably supports that characterization. We know that from the Hancock Supreme Court case, Supreme Court of Ohio case, 2006, Ohio 160, and this court's decision in Andrews, 2010, Ohio 6126. But here we don't even have the prosecutor calling Mr. Gorbe any names, as I think we heard acknowledged.
Counsel, what about, I'm looking at page 9 of the appellant's brief, and number 3, where it says, yeah, there are red marks here. Of course, there's red marks, and by the way, I've been doing this for 25 or 15 years, and I'm under oath here, and I'm telling you I saw red marks.
He's referring there to the police officer. He's not referring to himself. He's not expressing his own personal belief. I think he's saying the police officer testified, I've been doing this 15 to 25 years, and that's why I know what I saw, basically, at the scene. So that wasn't Mr. Razavi saying that.
So these 3 things, when the appellant talks about establishing in the jury's mind the concept that only his witnesses were truthful when he asserted, they're all going to what the officers testified to or other witnesses.
Yes, yeah, absolutely. That's what he was saying there. I think what we have here is the prosecutor pointing out examples from Gorbe's, both his direct and his cross-examination, which is exactly what you're supposed to do in closing argument. This is not a foul blow. This is strictly within the lines. Some of the things he pointed out, I'm just going to say, were as follows. The fact that most of the things Gorbe said on direct, he did not tell the police at the scene. That's perfectly reasonable, and that should be pointed out by the prosecutor in closing. The fact that we have Gorbe's admissions, such as that he threatened to kill his wife and unborn child within the past 24 hours. He confessed to that on scene. We have contradictions in Gorbe's testimony from his direct to his cross-examination. Most notably, on direct, we have Gorbe testifying that the victim basically just walked in the room and punched him in the face out of the blue. And then on cross, Mr. Razavi correctly explored the fact that to the police, he stated something totally different, and then he on cross stated something totally different, which is that there was an argument about other women. There was a jealousy factor, and that preceded the punch. So we have contradictions that he's pointing out as to why Mr. Gorbe is less credible than his victim in this case. The prosecutor also, during closing, rightly pointed out that Gorbe's story, testimony, seemed like a rehearsed story or performance for several reasons. He was very particular about very trivial facts, such as the fact that he had Fruity Pebbles for breakfast that morning, the fact that he took exactly 6 steps across the room before his wife punched him, the fact that he took exactly 13 minutes to get back to his house, not 10 minutes, not 15 minutes, not 20 minutes, 13 minutes. So he's got all these very particular facts rehearsed ahead of time in order to sort of make himself seem more credible, and that's a perfectly reasonable thing for the prosecutor to point out in closing. But then when he gets on cross and he's actually has to think on his feet, he pauses and he can't answer as quickly, and he has trouble getting his answers out. Those are perfectly reasonable things.
Well, and just what you just said, is that permissible for a prosecutor in closing argument to say that his testimony is rehearsed?
I don't think he actually used that term.
And
I know he
probably
used
not.
that term,
I'm not trying to pick on you, but I'm just trying to ascertain what is permissible and what's not. And if you characterize it and make your own conclusion that it's rehearsed, isn't that different than saying, ladies and gentlemen of the jury, does it make sense that somebody would remember they walked 6
exactly what he said. Yeah, that's what I'm trying to point out, is he didn't come out and say that. He said, is it reasonable to remember that you had Fruity Pebbles as opposed to Fruit Loops, and you took 6 steps as opposed to 4 or 5, yet you're contradicting yourself on this critical issue from direct to cross of what preceded this punch, how this fight started. He changes his story on these huge issues, yet he's got exactly nailed down what he had for breakfast and how many steps he took. That's something that...
And I think that's, to me, that's the issue we're seeing in a lot of these cases now. The individuals arguing, whether it's the prosecution or the defense or whoever, maybe go beyond that and think they have to drive it home and make the conclusion for the jury.
Right. I guess I'm making what I'm telling you here about this, as I'm saying rehearsed, I think that's what you can take from all that. That's a reasonable conclusion for the jury to draw once they've heard this. Right? They were never told, this is my conclusion, this should be your conclusion. There was nothing like that. That's why this is not misconduct. I'd like to also just get into the issue of prejudice here a little bit. I've been focusing on were they improper or not. Even if they are improper, it's important to remember that you still have to show prejudice. The fact that these comments altered the outcome of the trial, and that's a very, very high bar. And Gorbe, in fact, fails to argue exactly how any of the prosecutor's comments prejudiced him or denied him the right to a fair trial. And I think it's important to note that you also have to look at the whole context of the trial along with the defense's comments. And you have to look at what the defense said and what the prosecutor said. If the prosecutor's remarks are basically invited as a response to the defendant's remarks, you can't have remarks that are improper. I would point specifically to this court's decision, State v. Bowerman, 2014 Ohio 4264, where this court found that the prosecutor's arguments on credibility were actually invited by the defense argument that a state's witness was not credible. In that case, the argument was that the state's witness was bought and paid for, basically that they were testifying in exchange for a deal. And you respond to that by, as the prosecutor, saying why the other witness for the defense is not credible. At trial, defense counsel, as they're arguing here, basically said that the victim lied, made up her version of events in a scheme to gain leverage over Mr. Gorbe in divorce proceedings. That's a pretty strong attack on our victim's credibility. So the prosecutor absolutely had the right to make arguments about the credibility of Mr. Gorbe's story. It pointed out very reasonable and important facts about his testimony. So I'd just like to touch on also sufficiency and manifest weight. I'll address those two together. For purposes of sufficiency, we know that the testimony of a single witness is sufficient to prove any offense, if believed. And in a sufficiency consideration, you must believe the testimony of the state's witness. Gorbe on sufficiency makes a lot of arguments about why the victim was not credible, but that's not appropriate for a sufficiency argument. You don't consider credibility in a sufficiency argument. I would just point out in terms of the elements being met here by the testimony of our victim. The victim testified that she was assaulted by Gorbe on 2 occasions over the course of 2 days, both very drawn out and ugly incidents, saying that Gorbe struck her several times, dragged her across the floor, choked her several times, slammed her onto the ground, among other things. Bent her leg back and tore a muscle in her leg, while threatening her life repeatedly in the process, and the life of her unborn child. The victim also testified that she was married to Gorbe at the time this occurred, and that Gorbe knew she was pregnant at the time of the attack. I don't think either of those facts were in dispute by either side. The fact that they were married, so we have a domestic incident, and the fact that the victim here was pregnant. He and the victim both testified that he accompanied her to a doctor's visit 2 days prior to this incident where an ultrasound was performed. So there was no doubt that he knew she was pregnant. That's what elevated this case from misdemeanor to the felony 5. So we have all the elements of felony 5 domestic violence that were testified to by our victim here. On manifest weight, I like to often go back to this court's decision in the Tabassum case, 2011 Ohio 6790. Obviously, this is where you now get to evaluate the credibility, decide if the jury clearly lost its way, created a manifest miscarriage of justice. However, we know that evaluating credibility are still primarily functions of the trier of fact, who are in the best position to do that. And we know that we don't have a manifest weight issue just because the trier of fact credited the state's witness over the defense's witness. And we know that this court has stated that the trier of fact has the right to place considerable weight on the testimony of the victim, who was the state's main witness here. In this case, she was obviously believed over Gorbe. And that decision was based not only on their evaluation of her credibility, but also on the large amount of corroborating evidence that was present, that went with her version, but not with his. For example, the Brunswick police officers arrived on scene shortly after 911 was called here, and the victim was found basically curled up in a ball, shaking and crying. They observed injuries on her that were consistent with being assaulted. There were photographs taken that were introduced as evidence at trial, showing red marks and bruises all over the victim's body, on her neck, on her face, on her arms, on her legs. Those marks were consistent with her version of events and inconsistent with Gorbe's version of events. As I mentioned earlier, Gorbe also admitted on the scene that he had, within the last 24 hours, threatened to kill the victim and her unborn child. He admitted that at the scene. Gorbe's testimony, on the other hand, his story of how this happened was self-serving and inconsistent with all the other evidence presented. That's why he was found to be less credible, most likely. I would also note the point that at the end of the prosecutor's closing argument, it's basically stated that the prosecutor couldn't provide one unified theory of physical harm to the jury. But what the prosecutor was actually reminding the jury of at the end of his closing was a very important point, which was that they didn't have to agree on every single detail of how this went down over these 2 days. They didn't have to be unanimous in exactly how Gorbe committed the offense, as long as all of them were convinced that every element of the crime was satisfied. That's the only point he was making. This was a long and ugly assault, and there were a lot of details thrown their way. They didn't have to agree on every detail. They just had to agree that all the elements were met.
And counsel, you have about 5 seconds.
Okay, yeah, I'm done here. So the state of Ohio would respectfully request that this court affirm the judgment of the trial court. Thank you.
Thank you very much. Counsel, you have 5 minutes available for rebuttal.
Thank you. To follow up, the prejudice in this case, the plain error in this case, is the denial to the right of a fair trial. And Matthew was deprived of that right by the approach utilized by the state. The state cannot provide a unified theory, so it's the throw it up on the wall and let's see what sticks case. That's not what justice is about. That's not what due process is about. It's about proving beyond a reasonable doubt the elements of the offense. 2, as it relates to the claim of plain error, and I have to quote Mrs. Vizzelli on this, you can be a skunk, you can be a cheating skunk, but doesn't mean that a spouse has the right to punch you. Spouse doesn't have the right to kick you. Spouse doesn't have the right to bite you. Spouse doesn't have the right to take a lamp and hit you with it. That's called assault. The elements of assault do exist in this case. The assault committed by Mrs. Gorbe against Mr. Gorbe. As far as the previous arguments that I have made with respect to manifest weight and insufficiency, I won't revisit those other than to say my argument is in the brief. But as it relates to the denial of due process, there has to come a point in time where we draw that line as to what is proper and what is improper. And I think that line was crossed in this case. And the plain error, even though it wasn't objected to, is that Matt didn't get his day in court. This was an emotional decision, not one that was proven beyond a reasonable doubt. Thank you.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be accessed through our 9th District Court of Appeals website. Thank you, gentlemen.
Thank you.